Justice Hennessy, we spoke among council and we're hoping that we might carry through until about 4:50, 4:55 today. And then after that, some of us will hopefully stay behind to talk about plans for the future, the next few days.
The future.
The next couple of days, the next week to get through all of this. So we left at a new section at slide, I've lost it now. Thank you, 238.
238, yeah.
All right, so this is interesting because now we're moving from the appeal of the Dominion Provincial Arbitration Award to the Supreme Court of Canada and the JCPC. And can you start us off at slide 239, please?
Yes. The province of Ontario appealed the 1895 Dominion Provincial Arbitration Award to the Supreme Court, where their decision was reversed. The Supreme Court ruling held that, quote, the provision in the treaties as to increased annuities had not the effect of burdening the lands with a trust in respect thereof, or an interest other than that of the province in the same, within the meaning of said section 109. Ontario, therefore, they ruled, quoting, held the lands free from any trust or interest and was not solely liable for the repayment to the Dominion of the increased annuities, but only jointly liable with Quebec as representing the province of Canada.
Thank you. 240.
So these are the 5 Supreme Court justices, 3 of whom upheld the award, or sorry, upheld the appeal rather, and overturned the Dominion Provincial Arbitrators of 1895 award. The 3 that upheld the appeal were Chief Justice Strong, Justice Taschereau, Justice Sedgwick, and their position was that the treaties did not create a trust.
And you told us before that you're not a lawyer, so you
Yeah.
would not know that we don't talk about upholding an appeal.
Oh, I'm
We
sorry.
would talk about granting the appeal.
Okay, yeah, okay.
And so then 241.
2 were in a minority in rejecting the appeal. That's Justice Gwynne and Justice King. They supported the view of the 1895 arbitrators that the payment of annuities flowing from the proceeds of the treaty territories were a trust.
Now,
If
in the
you could
next,
just slow down for one
Yes,
second.
of course. Go back to
No,
yeah, 241.
Nowhere. Okay, thank you.
the next number of slides, Professor Messamore, you go through summarizing the decisions of the Supreme Court and the JCPC. And you say here that you're summarizing from the point of view of a historian. I think we've all agreed that the best person for interpreting the Supreme Court decision is Justice Hennessy. That's her role.
Yes.
But Justice Hennessy, we actually wanted to ask you whether you felt it would be helpful to have Professor Messamore at least summarize this to help provide context, I think, for what follows.
Yes, please.
Thank you.
Okay.
But of course, it's, I should note that the decision, the Supreme Court decision is at tab 18 of the compendium. The portions that Professor Messamore will be referring to have been highlighted. And so, of course, Your Honor and anyone can go and make their own interpretation of them. But in order to provide context for the rest of Professor Messamore's evidence, then we'll just go through this in a summary fashion then. Can we then start at slide 242?
Yes, so I just make the point that as a historian, I'm not equipped to assess the legal merits of any of these views. I'm just offering a basic summary of the main ideas the judges articulated in the reasons for judgment.
All right, so we're starting at page 243 of your slides.
Yes,
And here you're starting with Chief Justice Strong.
yes. Chief Justice Strong noted that in rejecting the appeal of the decisions of the section 1870, section 142 arbitrators, back in 1878, the JCPC did not consider the merits of that arbitration itself, only the validity of it.
This was a
Um,
point you made earlier.
Yes, I did, that one arbitrator had resigned, the other had moved. Chief Justice Strong recognized that it would not be possible to change the 1870 Section 142 arbitration, and that it had to be considered conclusive on all parties, on all the parties to it.
Now, the next judge whose decision who is reported in the case is Justice Taschereau, but he just concurred and didn't provide separate reasons. Is that right?
Sorry,
That's- Because you haven't summarized Justice Taschereau's
right,
position.
that's correct, yes,
Because he
yes.
didn't actually, he just said, I concur.
Yes,
with Justice
yes,
Strong."
yes, that's right, yes.
So then on the next page, at 244, you then summarize what Justice Gwynne had to say.
Yes, Justice Gwynne, in dissenting from the views of Justice Strong and Justice Taschereau, said that, quote, "the terms and conditions expressed in treaties made on behalf of the Crown, quote, have always been regarded as involving a trust graciously assumed by the Crown, to the fulfillment of which, with the Indians, the favor and honor of the Crown is pledged."
I'm sorry,
The faith and honor, faith and honor of the Crown is pledged.
slide 245.
Justice Gwynne also differed with Justice Strong on another point. To quote him, "the payment of the increased annuity is expressly made contingent upon the fund to be realized or produced out of the territories expressed to be ceded, proving to be sufficient to enable the government of Canada to pay such increased sum without incurring loss." He goes on to say the plain construction of Her Majesty's promise and undertaking is that such increased sum, in the event of the fund permitting it, should be paid out of the funds so to be produced, and so enabling the government to pay it without incurring loss. In other words, he rejected Justice Strong's assertion that there was no particular fund from which increased annuities should be paid.
And then at 246.
Justice Gwynne recognized that at the time of Confederation, quote, "there does not appear to have been any claim or inquiry made for the purpose of ascertaining whether or not sufficient funds had been produced out of the ceded territories to pay an increased annuity without incurring loss." He noted that inquiries as to this point began in 1873.
And then slide 247.
Justice Gwynne rejected any idea that clause 13 of the 1870 Section 142 award, which declared that the lands surrendered by the Indians, now held by the provinces, were, quote, "free from any further claim or charge, any further claim upon or charge to the said provinces in which they are situate by the other of the said provinces, in any way protected Ontario from the obligation to pay the increased annuities." So in other words, he rejected the idea that clause 13 in any way protected Ontario from the obligation to pay increased annuities.
So then at slide 248, you summarize the decision of Justice Sedgwick.
Yeah, Justice Sedgwick acknowledged that the
Can
62.
you remind us, was Justice Sedgwick in the majority or the minority?
He was in the majority.
Thank you.
Yeah. He acknowledged that the 62.5 million was the amount of debt absolutely assumed on behalf of Ontario and Quebec. It was, he said, quote, "provided that should the debt of the old province of Canada exceed 62.5 million assumed by the Dominion, those provinces should be liable to Canada for that excess with interest at 5% per annum."
What's he
goes on-
saying there?
He's saying that the amount of debt assumed by the Dominion government, or for which the Dominion government would be liable, would be a better way to put it, is limited to 62.5 million.
Hard cap.
Yes. And maybe we go on to 240.
So, but what's
I'm
he
sorry.
saying there?
I'm sorry, can we go back to 248?
What's he saying about the annuities?
It might be
I
fair
think
to look at the decision. Would you like to look at the decision? So we can see this quote in
oh,
context.
in context, okay. Yeah, yeah, I mean, this was
So
taken,
it's at tab 18 of the compendium. We'll find that quote. Justice Sedgwick's decision starts on page 95 of the compendium. Page 39 of 48 of the decision. And you see the portion that you've quoted from is highlighted there at page 95 of the compendium.
yes, yes.
So I think if you perhaps can either read it to refresh your memory or perhaps read it out loud. I'll give you a moment with it.
Yeah. Okay. Oh, no, sorry, that's a different point.
So I think Justice Hennessy's question was, do these particular comments relate to the annuities in particular here?
I would
To your
say
understanding?
these particular comments, not necessarily, no, they relate to a limited amount of Dominion liability for provincial debt.
Thank you.
And perhaps in the slide that follows,
249.
yeah, I elaborate more on what Justice Sedgwick says, which that would be slide 249, yeah. Which may,
Is this also general principles?
yes, I think that would be a way to characterize it. So he said that it was very clear that the Dominion entered upon its national existence with a fixed and disputable debt. The Dominion, he said, quote, had a right to recoup itself by calling upon Ontario and Quebec to make good the difference between the actual indebtedness and the net amount, which as between the provinces and itself, it undertook to pay, which would be 62.5 million. The actual amount of that excess has never yet been definitely ascertained.
Can
And
I
that-
interrupt you
sorry,
there?
yeah.
To say, I noticed that there's a typo in this slide at the very first paragraph. Justice Sedgwick noted it very clear that the Dominion entered upon its national existence with a fixed and indisputable debt.
Oh, gosh.
Yeah, if you look at the decision we were just looking at, it's clear that, and it's also clear from the context that you meant your indisputable debt.
Yes, sorry. I guess when I looked at that again, I wondered at it, and then I thought for a moment that perhaps what he meant was that one referring to the 62.5 million and the other, no, but of course it's the Dominion. So yes, certainly indisputable debt. That's an important typo.
And this really, as Justice Hennessy suggested, is sort of get the word that you use, Justice Hennessy, but
General
it's
principles?
general principles. General principles.
And so he said the actual amount of the excess has never been definitively ascertained. That refers to that process that was ongoing of adding and subtracting amounts.
Thank you.
Even he said the 1873 increase to the provincial debt allowances did not fully represent the liabilities of the old province.
And then we then move to slide 250.
250. Justice Sedgwick dismissed as irrelevant the distinction as to whether the treaties gave the Indians an interest in the ceded lands themselves or in the proceeds of those lands. He examined the phrase in the treaties that said, should the territory hereby ceded at any future period produce such an amount as will enable the government without incurring loss to increase the annuity hereby secured to them, in brackets, the Indians, then and in that case, the same shall be augmented. That's not, of course, the exact language, I think, but that's what he said. There was, Justice Sedgwick said, here no express creation of a charge, whether upon the lands or their proceeds. And I continue with this point on 251.
I'd like to
Oh,
go to
sorry.
that paragraph if you
Sure.
can, please.
Mhm.
So again, where we're seeing that is at
Mhm.
tab 18 of the compendium,
Yes,
and it's highlighted on page yes, it's on the bottom of page 98 of the compendium, 42 of 48 of the decision. And you continue on, Professor Messamore, on the next slide to continue on with the section that's further highlighted in the compendium.
Yes, Justice Sedgwick asked the question, did the Indians, in consideration of the cession, get the personal obligation of the Crown plus an interest in the proceeds of the ceded land to bolster it up, as it were, and make it more binding? Or did they get that obligation only? Justice Sedgwick concluded that, quote, for my part, I cannot bring myself to think that it was ever within the contemplation of the parties that as security for payment, the Indians were to have a charge upon the proceeds of the ceded lands.
so can I go back
Yes.
to slide 250, which comes from page 98 of the compendium.
Yes.
He says there is no express creation of a charge. Here he's saying in favor of the Indians. Or he's
There-
not saying in favor of Ontario, is he?
He's saying there's no charge or on the land.
Yes,
The treaty does not create a trust, does not create a charge on these lands.
right.
The promise is just, it's just the obligation only. It's not charged on the land.
Right. But he is rejecting the notion of a charge on the land by the Indians,
That's correct.
not by Ontario.
That's correct.
Right.
Okay,
Yes.
so
I'm sorry. Yep. Did I misunderstand?
because the issue is a trust on the land by Ontario, or Ontario saying it comes subject to a trust.
No,
Oh,
I think it would
by the
help.
Indians.
I think it would help to look at section 109. I really do. So section 109 is at tab 1 of the compendium. I know we've looked at it before, but just as a reminder about this trust language.
Page 5.
Page 5 of the compendium. So if I may, I'll read it out.
Mhm.
This is the provision that says that all lands, mines and minerals shall belong to the province of Ontario, in which the same are situated or rising. So Ontario
Mhm.
gets all of the lands in Ontario, subject to any trusts existing in respect thereof, and to any interest other than that of the province in the same. So the point here being, and I know I'm getting into argument here, Justice Hennessy, but the point here being that the argument that is made on behalf of the Dominion and Quebec is that the Indians have an interest other than that of the province, and the province, there is a trust in favor of the Indians upon those
Who's
lands.
saying that?
The Dominion and Quebec.
Right.
Yes, of course, Ontario would dispute it. And the Supreme Court agreed, the majority agreed with Ontario. They said there is no trust in this. The treaty doesn't create a trust in favor of the Indians. And that would take us back to what Justice Sedgwick is saying. At page 98. Because it says at the bottom of page 98, the part that right before where Professor Messamore quoted. If we are, then I think the Indians, anyway.
So what he's saying is the party who signed the treaty for the crown did not take the land subject to a trust.
I don't understand it that way.
Okay. You say that the trust issue only arises in section 109 first, like that's the first point in time a trust can exist. All the lands shall belong to the province subject to any trust existing in respect thereof. So it's presuming that that there could be lands at the time of Confederation on which there's a trust interest.
Yes, thank you. I probably answered too quickly before without really understanding your question. So are you asking for the Dominions and Quebec's position on this?
No, I was trying to figure out what when in time Justice Sedgwick
I see.
is speaking when he says there is no express creation of a charge. Is that at the time of the treaty?
Yes, yes, it is. At the time of the treaty, he reads the treaty provision and you see he cites it there. He comes to the treaty itself and says, what is the effect of these words? Is this actually creating a trust in favor of the Indians on this land? Just because it says, should the territory at any future period produce such an amount? As you know, does that create a trust in favor of the Indians or an interest in the favor of the Indians? And his conclusion is, no, it doesn't. All they had is just the obligation of the personal obligation of the crown. Like, anyway, I am very reluctant to get into argument here because I know my friend will have.
I think that's a good cautious way to proceed with the examination in chief. No, I'm really, I was just asking what either the witness or you understood that Justice Sedgwick was talking about. Okay.
I believe Justice Sedgwick said that a trust had not been created
At the time of the treaty.
at the time of the treaty, yes.
That the language of the treaty does not create a trust or interest in favor of the Indians
That's
in
what
the
he
land.
seems to be saying, yes.
That really the Indians ceded the land and that's the end of it. They have no continuing interest in it.
Says Justice
Says
Sedgwick.
Justice Sedgwick,
Got it.
yes.
Thank you.
Yeah. So if we could go to slide 252, I believe. Justice King. The question will follow. Justice King was in the minority here. He said he believed that debt, as mentioned in section 112 of the BNA Act, is comprehensive enough by itself to include a liability for increased annuities becoming payable after the union. But this particular liability, or part of the debt of the late province of Canada, is to be regarded as cast upon the province to which by section 109 the land is given subject to the burden. Can we move to slide 253?
I'm just catching
I'm
up.
sorry. Okay.
So really, if you could summarize, and please tell me if you can't, Professor Messamore, but if you feel you could summarize the competing views of the majority and the minority, how would you summarize those competing views?
The most simple way to do that would be that Justice Strong, Taschereau, and Sedgwick had the position that the treaties did not create a trust. Justice Gwynne and King believed essentially that they did, that the obligation to pay increased annuities, as the Dominion provincial arbitrators argued, could be considered a Section 109 trust.
Thank you. And I noted that you're not all that qualified to talk about this because you're not a lawyer. And then I
Mhm.
myself made a mistake by telling you that an appeal would be granted when in fact it would be allowed.
Oh.
And in the resolve, the appeal by Ontario was allowed. Is that right?
I'm sorry, an appeal beyond the Supreme Court? do we
Yeah,
mean?
the Supreme Court appeal, I'm just reiterating what you told us, which the majority decision was in favor of Ontario, that
Yes,
that there was no trust or charge on these lands that required Ontario to pay the annuities.
yes, that is correct. And the JCPC.
So now we're at
I'm
slide
sorry, yeah,
253.
slide 253. The JCPC heard a further appeal and affirmed the judgment of the Supreme Court and dismissed the appeal on the 9th of December, 1896.
And here on slide 253, I think it would be helpful for you to
Yes,
quote from that JCPC decision, which is also in the compendium at tab 19. But let's just have your summary of
Okay.
it here.
so the JCPC held that, quote, liability for these increased amounts was not so attached to the ceded lands and their proceeds as to form a charge thereon in the hands of the province under Section 109. They must be paid by the Dominion with recourse to the provinces of Ontario and Quebec conjointly under Sections 111 and 112, the same manner as the original annuities.
Thank you.
By the base annuities,
I'm
original.
sorry, yes, correct.
Thank you.
So this then requires a return to the Dominion provincial arbitration,
Yes,
because now we're left in a situation where the JCPC has confirmed that this is a debt of the province of Canada, which then has to be,
reflected in the new order by the arbitrators.
and that's going to deal with how that's paid by Ontario and Quebec to the Dominion.
Correct. Yeah.
So here, returning to the Dominion provincial arbitration, on slide 255, you talk about the 8th award.
Yeah, I just mentioned this as something, the 8th award made on the 20th of June, 1896 does not directly affect the Robertson Treaty annuities, but it does illustrate the limited and specific nature of the provincial debt allowances.
Could I, can you give me the date, the year of the JCPC decision, please?
Yes, it was,
No,
It's-
it's of,
judgment
sorry,
was rendered on December the 9th, 1896.
Thank you. Sorry, go ahead.
so the 8th award deals with a number of individual items that were in contention in the respective accounts of the Dominion, the province of Canada, Ontario, and Quebec. They went through them individually. Some items were found to be the responsibility of the province of Canada in the pre-Confederation era, others to one of the post-Confederation provinces, and others to the Dominion government. These individual items were ordered added to the respective debt accounts based on the individual findings. And I just mentioned this award in connection with the limited and specific amount of the debt allowances and how later discovered obligations were treated.
All right, can we go to slide 256 where we get into the 10th award, which is a very significant award?
Yes, so the 10th award of the Dominion Provincial Arbitration was made on the 7th of January, 1898. And this was necessary, as we've heard, because the original 1895 decision of the arbitrators had been overturned by the Supreme Court and the JCPC. The Dominion government, in consequence, made a claim against Ontario and Quebec jointly for the arrears in the Robinson Treaty annuities. Slide 257. Casalt referred to the relevant legal decisions and said that, quote, debt of the province of Canada in section 112 of the Act must have the same meaning as public debt in sections 110, 114, and 115, and I cannot conceive that the public debt of a state does not comprise all its liabilities as well as its debts ascertained and certain. To go on with the 10th award,
On page, slide 258.
Boyd, in his reasons, agreed, quote, debt as used in the Act is of scope enough to include liability. Public debt comprehends the aggregate of all provincial debts and liabilities existing at the Union, the sum total of existing claims. There's an indication, Boyd indicates that the terms debts and liabilities were used interchangeably and synonymously.
And you told us before that this was an issue because one of the arguments that Ontario had made before the arbitrators had to do with the potential distinction between debts and liabilities.
That is correct.
Right. And what do you say the 10th award says?
Um,
The 10th award says quite a lot of different things.
So the part of it that I understand is relevant to us here is that the 10th award provides for the fact that the Dominion government will charge the provinces of Quebec and Ontario jointly for the arrears that were deemed owing under the Robinson treaties.
Thank you. And then on slide 259 then.
Yes. Quebec appealed the 10th award on the 7th of October, 1898. The Supreme Court upheld the Dominion Provincial Arbitration 10th award and dismissed Quebec's appeal.
Can you explain for us why Quebec would have appealed the 10th award?
Yes, I think it would be because they were being saddled with the cost of annuities that would extend into a period where they had no benefit from those lands. And they were now being compelled to share in the obligation according to the 53-47 formula.
So we're now into a section that you call negotiated resolution. And here we go on to, we're still on the 10th award because the 10th award was dated the 7th of January, 1898. And
Yes,
you've
so
told
there
us
were,
that one aspect of it was this finding that Ontario and Quebec were conjointly liable to the Dominion, which really follows from the decision of the JCPC.
yes.
And now you discuss further orders that were made
Yes.
in that 10th award on the 7th of January, 1898.
Yes, and these I didn't delve into very much. I just simply list them because they're not sort of within my area of expertise. So these further orders concerned who had the burden of determining the eligibility of annuitants under the Robinson treaties. What was the criteria for inclusion in eligibility? And I say, for example, band membership, marriage, blood. And third, what expenditures should be taken into account when determining when the threshold to augment the annuities without incurring loss was reached. And then there's a subsequent award on the 2nd of December, 1898, Award 12, that again, I don't go into, but just mention. Award 12 concerns the method of preparing the provincial accounts held with the Dominion government to reflect the arbitration decisions.
All right, so we then get to Award 15. And Award 15 is in the compendium. Oh, no, I'm sorry, I've got the wrong one here. I'm looking at a different document, sorry. Award 15 yeah. Award, thank you very much, Mr. Fisk. The Award 15 is actually at tab 31 of the compendium, but I don't think we'll go to it right now. Can you go take us through your slides, Professor Messamore, so we can figure out what's relevant about it? You were on slide 262.
Yeah, I didn't start in this case with Award 15. I started with context because Award 15 issued on the 1st of December 1900 reflected a position negotiated. I'm sorry, 15, sorry.
You're on slide 262. You say Award 15 was issued on the 1st of August.
I'm sorry, no, is it August? I think, gosh. I'll have to look at the report. I'm sorry.
Yeah, it's at tab, what do you say, 31. And it is the 1st of August, 1900.
Yes. Is that what I said? Or,
Sorry, I thought you had, we're looking on slide 262.
yes.
And I thought you had said that the date of the Award 15 was December.
No, I'm sorry. What I said was Award 12 was on
I'm
the
sorry.
2nd of December, 1898.
Yes, that makes sense.
Yeah, so I just mentioned that one very briefly before moving on to Award 15.
Sorry.
Um,
I might suggest actually that we're just about at 10 to 5, and I think it would be a good point to break for the day and start fresh tomorrow with Award 15.
We'll break for the day then. Thank you all. And off the record.